Well, good afternoon and welcome, ladies and gentlemen. It's a tribute to our distinguished speaker, Rick Brookhiser, that we've gotten such a wonderful crowd this afternoon. Just please come on down. Are there any seats missing? Okay, there's one smack in the middle. It might help if people could move over one. But I guess that's about it. So just nobody tell the fire chief. This afternoon's lecture is one of the Alpheus T. Mason lectures in the James Madison Program in American Ideals and Institutions. The late Alpheus T. Mason was my own predecessor as a McCormick Professor of Jurisprudence at Princeton. He followed Corwin, who in turn followed Wilson, Edward S. Corwin, who followed Woodrow Wilson, and he was followed by Walter F. Murphy. The Mason lectures are generously supported by Princeton alum and friend John Hansel from New Hampshire. Mason instilled in his students a spirited enthusiasm and respect for the founders' ability to ensure for future generations the blessings of liberty through their careful crafting of the Constitution. So this lecture is sponsored by Mr. Hansel and other students of Mason in the hope that it will engender the same respect and enthusiasm for the vision of the founders by undergraduates today. And it is a privilege and an honor to welcome back to Princeton and back to the Madison program someone who's blessed us with his presence on several occasions previously, Rick Brookhiser. Brookhiser will be talking this afternoon about John Marshall, the man who made the Supreme Court. Rick Brookhiser is a senior editor of National Review magazine. His alternating column is called City Desk and Country Life. Mr. Brookhiser is the author of 13 books, including John Marshall, the Man Who Made the Supreme Court, published in 2018, Founder's Son, A Life of Abraham Lincoln, in 2014, James Madison, 2011, George Washington on Leadership, 2008, and Alexander Hamilton, American, 1999. Rick was into Hamilton before it was cool to be into Hamilton. Way out ahead of the curve as usual. Not the place conservatives are usually expected to be, but Rick was there. He's also a columnist for American history, and he wrote and hosted the wonderful PBS documentary, which was screened before its official release here at Princeton and the Madison program, the Washington and rediscovering Alexander Hamilton with Michael Pack, the distinguished documentary film producer. He appears frequently on the History Channel and on something called the Colbert Report. He curated, that didn't go over all that great. He curated Alexander Hamilton, the Man Who Made Modern America, which is an exhibition at the New York Historical Society back in 2004. For 20 years, he was columnist with the New York Observer, and he also has freelanced for various magazines, including The New Yorker, Cosmopolitan, Commentary, and Vanity Fair. Mr. Brookhiser was awarded the National Humanities Medal for his distinguished contributions to American history. He was also a Guggenheim Fellow. He received his Bachelor of Arts degree from, if you'll excuse the expression, Yale. Welcome, Rick Brookhiser.
Well, thank you, Professor George, for that introduction. Thank you all for coming out. It's a pleasure to be back here, back with the Madison program, back at Princeton. I just want to tell you I didn't write the same piece for Cosmopolitan and Commentary. They were two different pieces. I'm sorry that the Supreme Court has been so out of the news in the last few months, but I'll try to make this relevant anyway. The Supreme Court and the federal judiciary were the orphan of the founding. It was the branch of government to which the founding fathers had given the least thought. But after the Chief Justiceship of John Marshall, that ended. It became the peer of the legislative and the executive, and remains so today for good and for ill. So this afternoon, I just want to talk about who John Marshall was. I want to describe how he did what he did, I want to talk about one of his crucial cases, and then I want to talk about some of his enemies during his lifetime and after. The most important thing to keep in mind about John Marshall is that he was a country guy. He was born and raised in Fauquier County, Virginia, born in 1755. The first house he lived in was a log cabin. The second house was a frame house. The third had glass in the windows. So this wasn't quite Daniel Boone. It wasn't quite the frontier, but it was the country. He was out in the country. And he retained his country habits all his life. Even though he lived as an adult in Richmond, he spent 1 month a year when he was Chief Justice in Washington, D.C., spent many months in Philadelphia, 6 months in Paris. But despite all that urban experience, his country manners and his country habits stayed with him. The word that comes up over and over again when people are describing him, and it doesn't matter if it's someone meeting him for the first time or someone who's known him for years, is simple. They call him a simple man. He combed his own hair. His wife cut it. He rarely went to a barber. He didn't care what he wore. When he first rode circuit, which was a duty Supreme Court justices had to perform until the 1860s, and one of his seats of his circuit was Raleigh, the first time he forgot to pack a pair of pants. And he only discovered this when he arrived. The tailors of Raleigh could not make him an extra pair. They were all too busy, so he had to hear his cases sitting in his robe covering his legs. He had a very simple attitude towards drinking. He liked it. He liked it a lot. When he was Chief Justice, the wine merchants of Washington called their best stuff the Supreme Court because he was their best customer. When he became Chief Justice, the court already had a custom that when the justices deliberated, which they would do after a day of hearing cases, then they would go back to the boarding house where they were all staying because they almost all lived elsewhere. And then they would talk about the cases they'd heard over drinks and over dinner. But they could not have wine. They could only have wine if it was raining outside. And I assume this custom was to cheer themselves up. So Chief Justice Marshall would always ask one of his colleagues, often Justice Story, Brother Story, please look out the window, tell us what the weather is. And if Story said, well, the sun is going down in a clear sky, Marshall would always say, our jurisdiction is so vast that by the law of chances, it must be raining somewhere. So wine was always served at the Marshall court. Marshall loved simple games. His nickname in the Army was Silverheels. That's partly because his mother sewed socks with white heels, but it's also because he could jump over a bar resting on the heads of two men. There's a wonderful story about him as Chief Justice when a little boy is sent to his office carrying a message, and the boy is intimidated and anxious. So Marshall gets down on the floor with him and plays marbles. He belonged to a club in Richmond called the Quoits Club, which met every Saturday from April to October. And quoits was a game like horseshoes, but instead of being played with shoes, it was played with metal rings. And the point was to toss them over a post or a meg to see if you could circle it or get it as close as possible. And guests of the Quoits Club said that Marshall seemed to spend as much care measuring the distance from his quoit to the meg as he did in writing his greatest decisions. So this was the man. The man he admired most in the world was George Washington. He met him in the Revolution. Marshall volunteered in 1775 when he was 20. And he fought in 3 battles where Washington commanded. Brandywine in September of 1777, Germantown in October, and then Monmouth in June of 1779. And between Germantown and Monmouth, he was at Valley Forge, where Washington commanded once again. So he saw George Washington in victory, he saw him in defeat, and he saw him in this grim winter encampment at Valley Forge. And his conclusion from these experiences was that this was the man who made the revolution work. He was the rock on which it had rested. When Washington retired at the end of the war and gave his commission back to Congress, a few days later, Marshall wrote a letter to his old school friend, James Monroe, and he said, "At length, the military career of the greatest man on earth is closed. May happiness attend him wherever he goes. When I think of that superior man, my full heart overflows with gratitude." The man that Marshall hated was his second cousin once removed, Thomas Jefferson. Jefferson hated him in return. Marshall didn't hate many people. I think Jefferson was really the only one. There was one other Virginia jurist he disliked. Jefferson hated rather a lot of people, but Marshall was always high on his list. From Marshall's point of view, Jefferson was a demagogue, that he talked a good game about following popular opinion, but that he sought to manipulate it using the House of Representatives. He also thought he had been a disloyal Secretary of State, serving George Washington, carrying out his policies on the one hand, but undermining them on the other, and showing an unpatriotic partiality to revolutionary France. There was a crisis moment in the 1790s when a letter that Jefferson had written to an Italian friend of his, Philip Mazzei, got published in the American newspapers. Mazzei had published it in Italy, and then it was translated into French, and finally it got into English language newspapers, was published over here. And it turned out that Mazzei had written, "I could put you in a fever if I could name the men who have been Solomons in council and Samsons in the field, whose heads have been shorn by the harlot England." And members of George Washington's political party, the Federalists, interpreted this to be an attack on George Washington, because Solomon was the king and Samson was the judge of Israel. This is certainly how Marshall interpreted it. 4 years later, after the deadlocked presidential election of 1800, when Alexander Hamilton is writing Federalists who are thinking of backing Aaron Burr, because the idea was we've been fighting with Jefferson for so many years and he's tied in the Electoral College with Aaron Burr, maybe Burr would be better. And Hamilton's argument was, no, believe me, he's not. I know him from New York politics. Bad as Jefferson is, Burr is worse. And one of the Federalists he wrote was John Marshall. And Marshall's response was, well, you know Burr, I don't. I have to follow your judgment on him. But I cannot support Jefferson. And the way he put it was, the morals of the author of the letter to Mazzei cannot be pure. That's how a Virginia gentleman says he's dead to me. So after the Mazzei letter, there was no possibility of coming back for Thomas Jefferson. Jefferson thought that Marshall was a sophist, that he would take anything and twist it into a predetermined legal conclusion. He told Joseph Story, when Story had been nominated to join the Supreme Court, he said, "You must never give a direct answer to any question that Marshall asks you. If he asked me if the sun were shining, I would say, 'I don't know, sir, I cannot tell.' Because if you said yes or no, he'd turn it into Marbury versus Madison or some other decision." So this is who John Marshall was. He runs for Congress in 1798 because George Washington tells him to do it. From Congress, he is plucked by President John Adams to be his Secretary of State when Adams is cleaning out his cabinet in the middle of his term. And then we have to picture him and Adams sitting in the still unfinished White House at the beginning of 1801. It's the lame duck end of the Adams administration. He has lost the election of 1800 to the rival Republican Party, not the GOP, the ancestor of today's Democrats, the party of Jefferson and Madison. And it has been a blue wave election. The Federalists have lost the White House. They have lost both houses of Congress. So one thing that Adams is doing is trying to appoint as many Federalists as he can to as many positions as he can. And he has just learned that the then Chief Justice, Oliver Ellsworth, third man to be Chief Justice, has written him a letter complaining about his health, says, "I'm quitting. I can't do this anymore." So Adams offers the Chief Justiceship to the first man who held the job, John Jay, the great revolutionary patriot, diplomat, spy master, Federalist Paper author, and Chief Justice from 1789 to 1795. Adams sends Jay's name to the Senate. The Senate confirms him. Then he gets a letter from Jay saying, "I'm not taking the job." He says, his exact words were, "It lacks dignity, weight, and energy. I've been there, I've done that. I'm not going back." So Adams is sitting in his office with Secretary of State John Marshall, and he asks him, "Who shall I appoint now?" Marshall says, "I don't know, sir." Adams thinks for a minute and then says, "I believe I will nominate you." So Marshall's name was sent to the Senate. He was confirmed, and at age 45 in 1801, he becomes the fourth Chief Justice of the United States. He swears in his second cousin and enemy, Thomas Jefferson, a few weeks later. Now, the partisan balance of the Supreme Court, when Marshall joins it, there are 6 justices then, only 6. And of course, all of them have been appointed by Federalist presidents because that's all the presidents we've had, George Washington and John Adams. So 6 Federalists, nobody appointed by anyone from any other party. But after only 11 years, the balance has shifted from death and resignation to 2 Federalists and 5 justices appointed by Republicans, by Thomas Jefferson and by James Madison. The court has increased in size by 1 justice because the country is growing, so Congress has added another seat. So that's quite a dramatic partisan shift. And yet all these justices continue to agree with John Marshall's positions as their Federalist predecessors had. And they would continue to do this for decades. How did this happen? How did he do it? I think the first quality, and it's related to his simplicity, was his geniality. He was very easy to get along with. He would like you rather than dislike you, and people liked him in return. He also showed deference. If there were justices who were more expert in areas of law than he was, he would let them take the lead on decisions. If it was a question of land titles, they would go to Justice Todd from Kentucky, where land titles were very confused and there was a lot of litigation. So Todd was very up on this area. He would take the lead there. If it was admiralty law, it would go to Justice Story from Massachusetts, commercial state. Again, an area of Story's expertise. And when you give deference, you get deference in return. So it's not just the right thing to do or the nice thing to do. It's the smart thing to do. The third quality, the most important quality, was that Marshall was always the smartest man in the room. And everybody recognized this. Many of his judicial colleagues were very sharp legal minds themselves. Also, many of the advocates before the Supreme Court, men like Daniel Webster, men like William Pinckney, men like William Wirt. But they all acknowledged that Marshall was their intellectual superior. He didn't have a quick mind. It took him a while to get going. One man compared him to some large bird taking off. And he starts and he flaps and he kind of flounders, but then once he gets airborne, it's this powerful, direct flight. And William Wirt, who started as a lawyer on the Supreme Court bar, later Attorney General, he said Marshall's mind was like the Atlantic Ocean. Everyone else's minds were mere ponds. So that's the impression Marshall's thinking made on these men. The final factor is the passage of time. He's Chief Justice for 34 years, from 1801 to 1835. He's nominated by John Adams, and he serves until the second term of Andrew Jackson. This is still the record for a Chief Justice. Only a couple justices have served longer, but none of them Chief Justices. So he's had all that time to work his other qualities. Now, probably the most famous decision he gave was Marbury versus Madison in 1803. I wonder if it isn't a little too famous. I noticed that all the reviews of my book that were written by law professors, they all took on my interpretation of Marbury. It's like everybody has his own view, and they had to take this opportunity to expound theirs. And certainly Marbury is important. It's the first time that the Supreme Court strikes down a portion of a law passed by Congress on the grounds that it's unconstitutional. But John Marshall did not invent judicial review in this decision. That was a concept that was already out there. He himself had spoken about it at the Virginia Ratifying Convention in 1788. He was a delegate to his own state's convention to pass or not pass the Constitution, and he'd spoken of judicial review there. Alexander Hamilton had written about it in 1788 in the Federalist Papers. It was an idea that was out there that people understood. He's just putting it into practice the first time. I think the political meaning of Marbury is equally important because he was scolding the Jefferson administration. He was saying, you guys came in and you said we were the bad guys, you were the bad guys, we are the good guys, we are going to do everything right, unlike the Alien and Sedition Acts. But here, you've refused to give William Marbury his commission, which was signed and sealed, and you sat on it. Shame on you. Now, I can't let him have it because the law under which he is appealing to get it happens to be unconstitutional. But of this 9,500-word opinion, most of it is a scolding of the Jefferson administration. Probably the most important decisions he made, or the most controversial, certainly, at the time he made them, involved supremacy, the supremacy of the federal judiciary over state courts. And there was a series of these. Dartmouth v. Woodward, McCulloch v. Maryland, Cones v. Virginia, Osborne v. Bank of the United States. But the one I want to talk about this afternoon is an economic decision, and it affects the right of contract, and that's Fletcher versus Peck. Fletcher versus Peck grew out of a land sale that the state of Georgia had conducted in 1795. Georgia was the poorest of the 13 states. It had been a colonial dumping ground for British convicts. It had one port city, a few rice plantations. But what it had was land, 35 million acres stretching to the Mississippi River, what are now the states of Mississippi and Alabama. And if Georgia could sell off that land, it could balance its books. So it made a sale in 1795. It sold this tract for $0.015 an acre. It turned out that every member of the Georgia legislature except one had been bribed. The going rate for the sale paid by the land speculators was $1,000. One Georgia legislator had taken only $600. He explained he was not greedy. When the people of Georgia learned this, they elected an entirely new legislature which passed a repeal act. They struck the sale from the books. They burned the records of it in the public square of the state capitol. When the fire was about to be lit, an old man supposedly stepped from the crowd and held up a magnifying glass and said, "The remains of corruption should be burned by fire from heaven." So he focused the sun's beams on the papers, and up they went in smoke. The Repeal Act also said that any employee of the state who so much as refers to this sale will be fined $1,000. So it could not appear in a Georgia court. No attorney, no officer of the court could so much as mention the Repeal Act. Now, the original purchasers didn't want to hold on to this land. I mean, who would want to move there, right? It's all swamp and populated by Indian tribes, often hostile. What they wanted to do was flip their tracts. This was the great American mania of land speculation. It's been going on for 200 years. So the original purchasers all flipped their tracks for huge profits, and the second purchasers often tried to do the same. But what was the status of their purchases after the Repeal Act? One of the first things the purchasers did was go to the top of the legal profession. They went to Alexander Hamilton, who was no longer Treasury Secretary. He was in private practice in New York City, and they asked him for an opinion. And he wrote a short, little 500-word opinion where he gutted the Repeal Act. He said that it was impolitic and unjust. It was impolitic because if a state takes back its sale, who will make a future sale with it? It was unjust because it's wrong to take back a sale you have made. But most important, he said, it is unconstitutional because Article 1, Section 10 has a contract clause which forbids states from impairing the obligation of contracts. Now, Hamilton was very familiar with this clause because he's probably the man responsible for putting it in the Constitution. There had been a little debating at the Philadelphia Convention about a possible contract clause, nothing definite decided. The first time the contract clause appears is the final draft of the Constitution by the Committee of Style, which was cleaning up the language, reordering the articles, and then presenting it to the convention for a final vote. And Hamilton sat on that committee, and the great Hamiltonian scholar Forrest MacDonald believes that he is the man who stuck the contract clause in at the last minute. Now, of course, the whole convention voted to keep it there, as did the states that ratified the document. So, the purchasers have Hamilton's opinion in hand, but what can they do with it? They can't bring it to a Georgia court. The Repeal Act blocks that. They can't sue Georgia from out of state because the 11th Amendment blocks that. This amendment was passed in the 1790s. The Constitution originally said that citizens of other states could sue a state in federal court, but the 11th Amendment blocks that option. What can they do? The option they have left is if citizens of two different states are involved in a suit with each other, that can be a matter for federal court. So in 1807, Robert Fletcher of New Hampshire sues John Peck of Massachusetts. Peck has sold Fletcher 3,000 acres of Yazoo land. And Fletcher now says, you didn't have legitimate title to it because of the Repeal Act. I want my money back. By the way, this was an arranged suit. Fletcher and Peck were both land speculators. In the 20th century, it was found that the acreage on Fletcher's original filing was upped to bring the dollar value of it over the minimum that could be taken before the Supreme Court. The case is argued before the Supreme Court in 1809. There's a technical problem, so it is re-argued in 1810. And John Marshall writes the decision. He tracks Alexander Hamilton's opinion closely. He says that repealing a sale is virtually impossible. He says the past cannot be recalled by the most absolute power. He says, as Hamilton did, that it would be unjust. And then he adds, as Hamilton added, that Georgia is not a sovereign entity. It is part of a great empire. It belongs to the United States, which has a constitution whose supremacy all admit. And in the Constitution is Article 1, Section 10, which forbids states from impairing the obligation of contracts. And what Marshall adds to this decision, audaciously, is the language that the contract clause is a bill of rights for the people of each state. I mean, this should surprise you, because when we think of the Bill of Rights, we think of the first 10 amendments, we think of freedom of the press, we think of the right to keep and bear arms, prohibition against searches and seizures, all of those individual rights. But Marshall is saying, no, before these first 10 amendments, there was already a Bill of Rights in the Constitution, and that was the contract clause. And that's the importance that he put on the ability of people to make their own arrangements by contracts. So if you sign your name on a contract, you don't have to fear that the state will come along later and tear it up. Or you can't hope that the state will come along later and tear it up if you bring the proper pressure upon it. If you sign your name on the dotted line, the deal is done. And the reason that I bring this up and emphasize the importance of it, and Marshall would return to contracts and some of his later decisions, chiefly Dartmouth v. Woodward. But when we think of the Founding Fathers and who among them was responsible not for the political world that we live in, or even so much the ideological world, but the economic world that we live and work in every day, the one we think of is Alexander Hamilton, especially after the musical. And the musical gets this right, as it gets many things right. And Hamilton certainly foresaw the diverse capitalistic economy we live in. But his vision needed a legal armature to support it, and that was supplied by decisions of the Marshall Court, Fletcher versus Peck being one of the first and most notable. Marshall had critics in his lifetime. One of his most industrious was Thomas Jefferson. Jefferson wrote letter after Marshall's major decisions, criticizing them, carping at them. He said that Marshall's decisions were like eels of the law. He said he hangs inference upon inference like Jacob's ladder stretching from earth to heaven. He spoke of his twistifications of his reasoning. But he couldn't think of an obvious solution to the problem of John Marshall. The closest he came was a proposal to hold constitutional conventions whenever there was a legal case that raised a constitutional issue. And he ran this suggestion, as he so often did with many of his ideas, past James Madison, his younger friend and right hand. And Madison, as he so often did, gave a little tug on the guy wire that connected the dirigible of Thomas Jefferson to earth and sort of, brought him into a steadier flight. Madison said a string of constitutional conventions would be tardy, troublesome, and expensive. And Jefferson never made this suggestion in public. It was one of his bursts of insight or perhaps fantasy. He runs it by Madison. Madison says, calms him down, and that's the end of that. A public critic was Senator Richard Johnson of Kentucky. Richard Johnson was most famous for having killed Tecumseh at the Battle of the Thames in the War of 1812. He was second most famous for his campaign song, which was Ripsy, Rampsy, Rumpsy, Dumpsy, I, Dick Johnson, killed Tecumseh. But Johnson was a serious man. He was an earnest populist, an earnest Democrat with a small d. And his critique of the court, like Jefferson's, was that it was undemocratic. It was putting decisions in the hands of justices who were no longer answerable to the people. They had been ultimately picked by the people because they were nominated and confirmed by men who'd been elected by the people. But once they were on the bench, they could not be removed unless they committed a high crime or a misdemeanor. They were there for life. So, therefore, unanswerable to the people. And this disturbed Johnson. He proposed a number of constitutional amendments to fix this. One would have increased the Supreme Court to 10 justices, required a supermajority of 7 for any constitutional case. Another would have given the Senate a veto over Supreme Court decisions. None of these amendments ever made it out of Congress. They died in committee, died on the floor. A third critic of the Supreme Court, not of Marshall so much, but of the court, arises after the second time the court strikes down a law passed by Congress. And this happened in 1857 in the Dred Scott case. And the law that the court struck down there was what we call the Missouri Compromise. Dred Scott was a slave who had been owned in Missouri and then taken by his master to territories that were part of the Louisiana Purchase that had been ruled to be free territories by the Missouri Compromise, and then he had been taken back to Missouri, his slave state, former home. And his lawsuit argued, I have been taken to live in free territories, therefore I ought to be freed. And in Chief Justice Roger Taney's very long decision, one of the many points he makes against Dred Scott's argument is that the Missouri Compromise was unconstitutional because the Fifth Amendment forbids the federal government from taking property without compensation. And so therefore, to tell a slave owner he can't bring a slave into a territory would be a taking of property. You can bring your human chattel wherever the stars and stripes waves in a territory. This decision was attacked throughout the North, notably by Abraham Lincoln, who will attack it until the moment that he's inaugurated president, March 1861, by Chief Justice Taney, who is described as looking like a galvanized corpse at this ceremony. Lincoln admits that the decisions of the court are final with respect to the parties who come before them. So poor Dred Scott has to remain a slave. It's too bad for him. But does the decision have value as a precedent? And Lincoln proposed a distinction between Supreme Court decisions. He said there are those that are settled and those that are erroneous. And what is a settled decision? Well, he gave several qualities it should have. One is that it should be unanimous. Dred Scott was not unanimous. It was 6 votes plus 1 concurrence and 2 dissents. The Supreme Court had increased to 9 justices by then. He said there should be no apparent partisan bias in the decision, and there certainly was in the Dred Scott decision. He also said it should not change previous practice of the government. And certainly those first 2 qualities of his, unanimity and no apparent partisan bias, would overturn some of the Marshall Court's decisions. There are many unanimous decisions, but not all of them. Dartmouth v. Woodward was a tangle of concurrences with a few dissents thrown in. So even some of his greatest decisions would have failed Lincoln's test. Lincoln threw this out in a speech, but never tried to implement or legislate on the basis of it. So it may be that we have to live with this tension in our constitutional life. I would call John Marshall a populist in the sense that he believed the supreme act of popular will was the ratification of the Constitution. This is something he said over and over again. But the Constitution, once in place, has to be adhered to, and when a dispute takes the form of a legal case and it reaches the Supreme Court is literally the last court of appeal for John Marshall. If this is undemocratic, and it may be, we have to make the most of it, or certainly we have tried for many years. And whenever any party is on the outs and feels that the Supreme Court is ruling against them, Senator Johnson's arguments and Thomas Jefferson's arguments against the court seem very attractive. For many years it was Republicans who felt this way. Now I think some of their Democratic friends are also feeling a little anxiety about the Supreme Court. Marshall lived until the administration of Andrew Jackson. Thomas Jefferson had been his enemy for the 8 years Jefferson was president. So was Andrew Jackson for related reasons. But Marshall had triumphed over Jefferson when Marshall was young. He confronts Jackson when he himself is old. When he dies, I think he feared that he'd failed, and that his project of building up the prestige of the court and defending the American Union was likely to fail. He was worried that the country would pull apart, as indeed it did in 1861. Jackson gave a very gracious tribute to him after his death, far more gracious than anything Jefferson would have said or than anything that Marshall would have said about Jefferson. But the most moving tribute to him, I think, came from the Quoits Club in Richmond. They ruled that since Marshall was irreplaceable, the Quoits Club should always have one fewer member. So thank you very much.
Thanks so much, Rick. Well, the floor is open for questions. We have a custom in the Madison program of recognizing student questions first. If any students are here who have questions, we will pass you a microphone. Students means students from anywhere. High school students, students from Yale.
I'm a student lifelong.
Students. Lifelong students, yeah. Well, in that case, they all will ask for it.
That's right. There you go.
Yes, right, Akil. Yes, our founder and leader of the Campus Federalist Society. Akil, you've got the floor.
Thank you for that talk. That was great. I had a question. You talked about how President Adams offered John Jay the position first, and he refused. Before Marshall got on the court, did he have an idea of where he wanted the court to go, a vision for the court, to sort of rectify the kind of stuff that Jay saw in the status quo, or was that something he discovered later once he actually got on the court?
Well, he had his profession was the law. He was a lawyer in private practice after the Revolution, and a very good one and very well compensated one. He had spoken about the judiciary at the Virginia Ratifying Convention in 1788. And there you see a prevision of some of the positions that he will take as Chief Justice. I mentioned the fact that he talks about judicial review, that if the legislature were to pass some outrageous unconstitutional act, who would be your bulwark against that? Well, it would be the judiciary. That's who we'd have to rely on. In terms of all that he did as Chief Justice, I think that was kind of a lifelong improvisation. There he is. He's put in this situation. He takes counsel with his fellow justices, and sometimes he lets them take the lead. One of the things the Jefferson administration did when it came in, John Adams and the Federalists in their lame duck days had increased the size of the federal judiciary. This was partly a patronage scheme to have seats to fill with fellow Federalists. But there had been problems with the judiciary as it existed. Supreme Court justices had to ride these huge circuits that were hundreds of miles over terrible roads. There was one justice, his horse ran away with his carriage and he was thrown out and the wheel ran over his leg. Another justice fell through the ice on the Susquehanna River trying to cross it in the winter. I mean, he was pulled out, he was okay, but it couldn't have been a lot of fun. So, and John Jay called it intolerable. This was in a letter. He didn't say it in public, but he hated this. So in 1801, the Federalists passed a Judiciary Act which increased the number of circuit court judges and meant that the justices wouldn't have to do this anymore. So when the Republicans come in, they repeal the Judiciary Act of 1801 with a new Judiciary Act of 1802. And they bring the court system back to the size it had had, which meant that the Supreme Court justices have to ride circuit again. The one change they made was they instead of 3 circuits with 2 justices for each, they made 6 circuits with 1 justice, so the circuits were somewhat smaller. So then there was a question, should we accept this? Should the federal judiciary accept this? And one of Marshall's colleagues, Justice Samuel Chase, said, you can't, justices serve for good behavior. And taking away a judge's or justice's job is the same as kicking him out of his job. I mean, it's something that you can't do, you shouldn't do. And another thing that the Republicans had done, they got rid of the Supreme Court's summer session. They used to have a winter session and a summer session. So they passed this new Judiciary Act in the spring. They get rid of the summer sessions forever. We've never had them again. And this means that the Supreme Court can't rule on it right away. And so Chase said, we should all get together anyway, figure out what we're going to do. And that's Marshall's inclination. That's his first reaction. But he polls the other justices, and most of them say, nah, let's not fight this fight. And he agrees with them. You know, he agrees with his colleagues. So this is something, I mean, he didn't have a rigid position going into this. He kind of played it by ear. It shows he knew how to pick his battles. In a very different context, years later, he said in a letter to Justice Story, "I'm not fond of butting my head against a wall in sport." So that's also a quality of this man. I mean, when he decides, it can be, you know, decisive, like 9,000, 10,000, 11,000 word decisions. Bam! It's like dropping a load of granite. But he waits for the cases to come to him. You know, he's not out there hunting for the cases, and sometimes he lets things, you know, slide. He lets things ride. So I think that's a larger answer to your question.
And the Jeffersonians impeach Chase.
Yes, that's right.
And he survives by one vote in the Senate?
No, it's more than that.
It's
more than that. It's a bungled prosecution. But Marshall is afraid. He's afraid that if Chase is impeached and convicted and removed from office, the Jeffersonians will just clean out the whole court. And he's so alarmed that he suggests that maybe the legislature should have a veto over Supreme Court decisions. This is the only time he approaches to anything like that. That's a measure of his fear at that moment. But the Chase prosecution breaks down. It's bungled by the House managers, and Jefferson also lets it slide. I mean, like his cousin, he doesn't like fight to the bitter end. If something's not working, he lets it go.
We have some students down here.
I know there are two of them. Which do you?
I realize Marshall's contributions to the Supreme Court are significant, but was he chosen to be on the Supreme Court due to his knowledge of the law and the Constitution, or was it politically expedient?
Both. You know, look, politics is omnipresent. You know, you never get rid of it. It's always there. But Adams picks him. Adams picks him partly because he's been working closely with him as Secretary of State. So he's seen him, you know, up close and personal for almost 2 years, and he has a very good impression of him. But he also knows this is a man who's done very well as a lawyer in Virginia. He argued one case before the Supreme Court. He lost, but he was very impressive. You know, people saw him arguing before the Supreme Court, liked what they saw. Also, he's young. He's 45 years old. You know, Adams is looking ahead to the future. So the answer is all the above.
And right next to you, you've got a question? Go right ahead. Yeah.
Did Marshall have any strong feelings about the election of 1824 that Jackson called the corrupt bargain? Did he have any feelings about that?
He probably voted for John Quincy Adams. He mostly didn't vote as Chief Justice. He would have voted. He voted for John Quincy Adams because Adams's father had picked him on the court. I mean, this was just, you know, like personal payback. He was very upset when a newspaper article appeared saying that Marshall believes that if Jackson wins, that's the end of the Republic. And Marshall had told someone that he was going to vote for Adams, and this person drew that conclusion from it. And the newspaper printed it as Marshall's opinion rather than the opinion of the auditor. You know, there was a little game of telephone, and that's how it appears in the paper. And he was very upset by this. He thought that this was, you know, something that a Supreme Court justice should not be involved in, and he printed a rebuttal in a friendly newspaper. So yeah, this was one time he took an open political position, but was very sorry that it got a little twisted. So let that be a lesson to all you Supreme Court justices.
We have another student question back here. Yes.
Thank you. I was very curious when you said that the concept of judicial review wasn't really something that Marshall had come up with. So I was kind of curious if you could talk to, was it something that the Federalists had been big supporters of, and maybe the Democratic Republicans really weren't. I mean, how prevalent was this idea? Because, I mean, I know I always had been taught that, like, Marbury versus Madison was just this brilliant tactical move on Marshall's part. And I'd be curious.
It was.
about
I mean,
his-
that's true. I said Marshall hated Jefferson and maybe one other man, and that was a Virginia jurist named Spencer Roane, who was a fellow Richmonder, sort of lived around the corner from Marshall. In Richmond, like everybody lived around the corner from everybody. And they still do, They've known each other's business for 200 years. But so Roane detested Marshall and his decisions. Marshall returned the feeling. But Roane was the Chief Justice of, I'm forgetting the exact name, but the Virginia State Supreme Court. I think it was the Court of Appeals. And he was the senior justice of the Court of Appeals. And in Virginia, he practiced judicial review with respect to Virginia statutes. Now, he didn't want the U.S. Supreme Court doing this, certainly not with state court decisions, because he thought, as he put it, the Constitution was really the Articles of Confederation somewhat expanded. So he still believed in a concept of state sovereignty that was much more aggressive certainly than Marshall believed. But so, he did judicial review himself in his own bailiwick. So it was sort of a bipartisan notion. I mean, it was entertained by people in both parties.
Other student questions? Yes, right over here. Yeah.
Lots of Marshall's opinions have had tremendous impact on how the Supreme Court operates to this day. Was he personally aware that some of his bigger opinions, like Gibbons, McCulloch, Marbury versus Madison, was he aware that these opinions would have such an impact? Did he anticipate the significance of these opinions and rulings?
Well, I think he hoped. And this is always balanced by his fears of what may happen to the Union. We have to recapture that moment. Today we are so used to the federal government obviously having supremacy over the states. But in Marshall's lifetime, that was not the case. And in fact, it all blew apart in 1861. The whole thing came crashing down. So, and Marshall did not predict that slavery would be the issue that would cause it, but he certainly feared disunion. And he wrote letters at the end of his life, fearing it, predicting it. So with that as a kind of a dark background, he is hoping to lay down markers and precedents that hopefully will, among other things, stop this. He also wants to increase the what Hamilton called the veins of commerce. He wants to secure contracts. I mean, he has a number of things that are dear to his heart, but among them is the preservation of the Union, and there he had great anxieties.
Other student questions? We have one up here. Yeah.
Thank you. I was just wondering what you think Marshall's reaction would be to the Supreme Court of today. How do you think the Supreme Court has kind of evolved since Marshall's tenure?
Well, let me tell you how Marshall ruled, and you can all decide. I think the two principles he seems to have used were an originalism of words and an originalism of intentions. And they aren't always 100% in sync. In his Dartmouth decision, this is where Dartmouth College had a charter from King George III, and it said, there's X number of trustees, and they get to pick the president, and they get to pick their successor trustees. And so by the early 1800s, the Dartmouth was this self-perpetuating institution which was very Federalist and very Calvinist. I mean, they were all Congregationalists or Presbyterians. And this was a particularly odious combination for Jeffersonians. And so the state of New Hampshire went over to the Republican Party, and a new governor by the name of William Plumer, who was an ex-Federalist. He'd just become a Republican. He and the legislature wrote a law saying, well, it's going to be Dartmouth University henceforth. We're doubling the number of trustees. We're also creating a board of overseers who will sit over the trustees. All these new people will be appointed by us. And all we want to do is open Dartmouth to all opinions. Who could disagree with that? Education is very important. You should have, Federalists, Republicans, everybody. That was their argument. Dartmouth went to court to say, well, we want to be what we want to be. And you can't just come in and change us because you think it's a good idea. We have a charter, and we want to stick to that. So it goes up to the Supreme Court. Marshall upholds the charter on the grounds that it is a contract. And he says in his decision, did the founders anticipate that the contract clause would apply to the charters of colleges? Probably not. But he says if it falls within the words of the rule, then it has to follow the rule. So I would say that's originalism of words. Other times he looks back to what was in the thoughts of the framers at the moment they wrote what they wrote. Often he's referring to what he believes was the chaos of American lawmaking between independence and the ratification of the Constitution. You had 13 new state legislatures, no more control by colonial governors. The horizon is the limit. They pass laws, and then the next year they undo the laws, and it's back and forth. And Marshall often uses the phrase that they destroyed confidence between man and man because no one could count on a deal. You can't make a deal because the people in the state capitol can come in and change all the rules. So that is kind of a fallen America that Marshall believed the founders were alarmed by and wanted to rectify. So in other decisions, he's looking to intentions. Okay, so those are the two arrows in his quiver, which he fires over and over again. So I leave it all to you to, apply that to the newspaper.
True historian. Well, we can open the floor now more generally, but I'll give myself the privilege of asking a question. I was so struck, Rick, by what you said about each man's criticism of the other, Jefferson's criticism of Marshall and Marshall's criticism of Jefferson. And then I'm thinking, well, neither one is completely wrong about the other.
Right.
Jefferson could be demagogic. Marshall could be a sophist. Now, it would be wrong, I think, to characterize either of them straightforwardly and purely as a demagogue and a sophist. But they had each other's number to some extent.
Well, let me stick up for my guy here. Jefferson had legal training. He had it from George Wythe. Actually, Marshall also had his only legal training from George Wythe. He took a course from George Wythe at William and Mary for a year. That was the sum of his legal education. Also, his father made him read Blackstone when he was a lad. So, if you want to be the greatest Chief Justice ever, that's what you should do. But I think his legal mind was more legal than Jefferson was. And I think Jefferson is more of a philosopher in a way. He's got a philosopher's attitude. He's sort of looking at what ought to be and what should be. And, certainly Marshall is not ignoring those considerations, but he's also, all right, here's the Constitution, here's this case, here are the circumstances, here's the laws. He's more focused on that. And that often looks to laymen like sophistry. Think of all the lawyer jokes, okay? I mean, really, this is what we who are not adepts think of the law. God, they get together in these rooms and they come up with these decisions, and how did they do it? Well, they're doing it, because there's a case, and there are like two sides here. And someone is being screwed, and someone else maybe is trying to screw them, or they're both being screwed, or there's money at stake, or freedom, or something, and they're fighting, and they want to win. And you have to decide. You have to decide. It's in your lap. And that explains some of the complication of the law. So I think Jefferson, and it's one of his great virtues, that he can, kind of step back and take this sort of Empyrean view of things. But does that fly in courtrooms? Not always.
It's the danger of being a biographer. You fall in love with your subject. Okay, Mike Brosnan. Yeah, Mike. Chanel will hand you the microphone there.
Thank you for your talk. Supposing John Adams eked out a victory in the 1800 election, do you think he keeps Marshall at state, or does he offer him the Chief Justiceship?
Well, I think Jay would have continued to refuse it because he was just disgusted. So that's a good question. One of the reasons that he turns to Marshall is he has to get someone who's right there. The clock is ticking. There isn't time to send a letter to, New Hampshire or Georgia or someplace. Here's the guy right in my office. This will speed things up. So there was a lot of contingency involved in it. Marshall, by the way, had been offered a seat on the Supreme Court earlier, which he'd turned down. He was offered a seat to be an associate justice, and he said, no, I'm doing my legal practice. I'm making good money. So.
Yes, I think there's a question up there. Yeah. Evie will hand you a mic.
Thank you so much. I was wondering, did Marshall believe that there were limits to the scope of judicial review, and that judges should, in some cases, exercise restraint on legislation that's really consequential?
Well, one kind of sad case where he certainly does that is called the Antelope. And the Antelope was a slave ship that was hovering off the coast of Georgia and was taken into Savannah by a revenue cutter. And this was when slavery, the slave trade, became illegal in this country in 1808, and then it was classed as piracy in 1820. And the Antelope is taken right about that time. And it's a very complicated case. There was a ship that sailed from Baltimore under bogus South American colors, and they captured the Antelope, and they went across the Atlantic, and the first ship sank, and then the Antelope is trying to unload its slaves. And then the parties who appear in court are lawyers arguing for Spain and Portugal, which were countries whose citizens had owned most of the slaves on that ship. But there were also some that had been taken off an American ship, which means they should not have been there. It was illegal for them under our law to have been there. And they end up being sent to what's now Liberia, because there is a law that provides that slaves brought into the country shall be removed from it. And this was done with the American Colonization Society in hopes of setting up a colony for freed slaves. And Marshall follows positive law in this. And he says that, certainly the slave trade is a violation of natural law, but courts must follow the laws of nations, and no nation has rights over any other. He says Russia and Geneva have equal rights. Now he's picking Geneva because it's a little Swiss city-state, and he's picking Russia because it's the largest country on earth. I think he's also picking them because Geneva was sort of free and Russia was an autocracy. But he's saying neither size nor your freedom or your internal regime gives any nation rights over any other nation. So I have to think seriously about these Spanish and Portuguese claims. He dismisses the Portuguese claim because no Portuguese person has appeared in 5 years by the time the case gets to the court. And he says this is just fantastic that property of this value would simply be ignored. And I mean, what he was really saying is it wasn't a Portuguese claim. It was Americans, using a bogus Portuguese flag to try and get these slaves out of Africa. He accepts the Spanish claim, and the upshot is that, about a third of the slaves end up freed going to Liberia No, more than a third, more like 2/3. And then the fate of the Spanish claim, this was such a sleazy thing. A congressman got Congress to pass him a special bill allowing him to buy the Spanish claim. So he retired to Florida with 30-some slaves where he wrote Byronic poetry while they labored for him. But so this is a disheartening example of a lawyer following the positive law. And Marshall would have said, well, that's what I'm retained to do.
Next question. Yeah, down here. Evie?
So, in response to Worcester v. Georgia, Jackson famously said, Mr. Marshall's made a decision, now let him enforce it. And at times throughout history when there's been Supreme Court decisions on particularly controversial and undecided topics in the public opinion, there's been questions of should the president just not enforce this decision? Should the legislature pretend it never happened or pretend that it's, or say that it's wrong and therefore invalid? Did Marshall write anything on this or say anything on it?
The way that got resolved is interesting. The quote you said, which we've all heard, may be apocryphal. I mean, it's like Horace Greeley said, "Oh, I heard a senator heard Jackson say this 30 years ago." So it's a very old quote, but that's certainly Jackson's attitude. I mean, and Jackson did write a letter at the time saying the decision has fallen stillborn, meaning the state of Georgia is not going to accept it, and I'm not going to pressure them to accept it. Now, what could have happened next? Samuel Worcester was a missionary to the Cherokees. The state of Georgia wanted to break up the Cherokee Nation's territory in Georgia, either kick them out or any Cherokees who remained would have to be ordinary citizens of Georgia, which means for a person of color, it's not very nice to be an ordinary citizen of Georgia. So the case goes to the Supreme Court because the state of Georgia has imprisoned Worcester and another missionary for violating Georgia laws against white people living on this territory that they intend to take over. They said anyone living there would have to take an oath of loyalty to the state of Georgia, and the two missionaries had refused. So they got jailed. So the case goes to the Supreme Court. Marshall rules in favor of the missionaries. Jackson says what he says. Georgia has no intention of obeying this. They make no argument before the court. They don't send a lawyer, the hell with the court. Now, what could have happened, what was about to happen, was that the missionaries would have asked their lawyer to inform the court that the law was not being enforced. And the job of the president is to see that the laws are executed. So then the next step in the chess game would have been the court would have had to write the president and say, oh, by the way, here is this law. It is your job as the chief executive to see that it is enforced. It doesn't get there because at the same time this is going on, there is the nullification crisis. South Carolina has refused to have the federal tariff collected within its state. And Andrew Jackson wants a force bill from Congress allowing him to collect it by force if necessary. And to do that, he wants a united front. He wants every other state to unite against South Carolina. If Georgia feels that Andrew Jackson is going to force it, to obey the court's ruling, Georgia will join South Carolina. And maybe Alabama and Mississippi also, because they also have Indian nations within their borders, Choctaws and Chickasaws. So the missionaries' bosses, the New England Board of Missions, which employed them, told them, drop your suit. Don't break up the country for your case. It's lost anyway. Georgia's against the Cherokees, Jackson is against the Cherokees. Just drop it. So the missionaries did. And then when the Cherokees were finally expelled and marched to Oklahoma, they went along with their parishioners. And Worcester and his partner end up dying in Oklahoma. But, they were leaned on. for the good of the country, you have to abandon your suit. So we don't know what would have happened. I mean, it's an interesting question. How would Andrew Jackson have reacted to such a communication from the Supreme Court? One can only imagine. But that's how that story ended.
Next, yes, can you just pass the microphone on over? There we go. Well, this fellow and then you.
My question is about how Marshall's decisions were basically influenced, and how he was able to be so influential with the other justices. If you look at today's court, the conventional wisdom is that justices negotiate the scope and depth and breadth of a decision in order to achieve consensus. To what degree did Marshall follow a similar process?
Well, there's some signs that may have gone along. There's one decision, it's a land case decision, where he gives the opinion of the court, and he actually says, and this is very rare with him, he says, I have some questions about this opinion, but I'm content to deliver what I've been directed to deliver. So even though this is a Marshall decision, I mean, he's indicating that there was some, discussion back in the scenes. And there was no Bob Woodward to tell us what it was. And there's some other cases where, for accidental reasons, the veil has lifted a bit, and we can see that there was talk of this kind going on. And certainly at the end of Marshall's tenure, he's in the position of hoping to get 4-3 majorities, which is a big change for him. I mean, he's lost control of his court.
Could you just hand the microphone on?
Thank you for your talk. Thank you very much. Couple words. What was his education? You mentioned that he was simple man. What pushed him to get that education to become specialist in law?
Well, he had very little education. He had a year of schooling, and then his father, who was kind of the local big deal in Fauquier County, hired a minister for their church and had the guy live at home, so he tutored the Marshall family children. Basically, he was homeschooled. One thing his father made him read was Blackstone's commentaries on the laws of England. Another thing was Alexander Pope, the poetry of Alexander Pope, and Marshall copied out the essay on man by hand and may have memorized it, which is kind of interesting. I think Marshall was not a poet, but I think what he may have picked up from Pope is a sort of voice of authority, which Pope can certainly use in the essay on man, and which Marshall also has. And then he had no college, and he only spent took this one course at William and Mary from George Wythe. So that's the legal education he had. Blackstone was a pretty good place to start. I mean, Blackstone was regarded as the authoritative commentator on the English common law. If you wanted to know what the law was in England, you went to Blackstone. And so Marshall kind of had that in his bones under his fingertips. And he said his father marked him out for a lawyer. And a lot of his brothers were also lawyers, so Thomas Marshall must have wanted his sons to be lawyers. And so that's how he was trained. I mean, that was the direction he was pointed in. Obviously, he took to it, and the rest is biography.
Yes, ma'am.
During Marshall's tenure, were there any conflicts over control of the Treasury by the House of Representatives and the Marshall and the presidents, sort of as a precedent for what we're seeing today?
No, I think the big thing was whether there should be a Bank of the United States, which is often called a forerunner of the Federal Reserve. It isn't quite, but that was a Hamilton brainchild, and there was a first Bank of the United States for 20 years, and then it's charter was not renewed, and then a second bank was created after the War of 1812, and Andrew Jackson ultimately vetoes the renewal of its charter. And Marshall's decision in McCulloch upheld the constitutionality of the banks of the United States, and he really tracks Hamilton's arguments that they were constitutional very, very closely. So that's the closest thing, which isn't very close.
Next, yes, Dr. McShay.
Thank you. It's a simple question that relates to the education question. As someone who's studied Marshall closely, you say he was a simple man, simple education. Do you have any sense of his library when he died? Was he a reader? And if he was, any sense of the topics that interested him?
He loved Jane Austen. There's a wonderful letter. Probably his favorite fellow justice was Joseph Story, who was 24 years younger, and I think was really a surrogate son. Marshall's sons were just not his peers. Story really was. Story was brilliant. He admired Marshall, adored him, so they had this like ideal kind of thing going. And Story was a hyper-prolific. I mean, he just wrote and wrote and wrote. And he sent Marshall a lecture that he gave to Phi Beta Kappa, where he's surveying everything we know today. And he has a list in this lecture, he has a list of women authors. Even women are authors today. Isn't this great? And here they are. And then Marshall writes him and says, you didn't include Jane Austen on your list. And he has a very, very short, very sweet, and very kind of accurate why I like her, why she's good. And he's implicitly comparing her to Walter Scott. He says, she doesn't rise on eagle's wings, but, she's very, very observant. And so that's good taste.
Good, yeah. Professor.
So thanks for a wonderful talk and an even more wonderful book. But I noticed that one subject that doesn't appear in the book is religion, and not just Marshall's own commitments, religious commitments, but how he thought about church and state, for example. And this is in contrast not only to Madison and Jefferson, but also to Story and Washington and some of these other folks who have a lot to say, Adams, about church-state issues. So I wondered, in your research, how would you characterize his church-state views, his own religious commitments, anything along the Marshall and religion axis you want to talk about?
Marshall was a Unitarian, but he belonged to the main Episcopal Church in Richmond. His wife was a devout Episcopalian. So I think there was a certain amount of family, politics and peacemaking, that he belonged to this church. He owned a pew. There's a description that he'd stick his legs out in the aisle. They were long legs, and he'd stick them out there. And then there was a story I came across. It could be apocryphal, although I see how it could possibly be true. Supposedly Marshall is in an inn, and he overhears some young men, just talking blasphemously in the way that enlightened, figures could. And he listens to this for a while, and then he interrupts them and says, but no, Jesus is, he's this, he's that, he's all these worthy, important, honorable things. But I could imagine a kind of, Christian favoring Unitarians saying that. Not that he's the Christ, not that he's part of the Trinity, but that he was the greatest man and he's our moral example and our moral teacher. So don't be so, cut out this scoffing. I could imagine a person of Unitarian views saying that. So possibly it's true. All he says on his tomb is the dates of his birth, his parents, the date he married his wife, and then he left the blank for the day that he should die. And that's it. That's my life. These are my parents. This is my wife. These are my dates. I know I did this, I did that. Here I am. So, and as far as church-state issues, they just don't come up. They just don't take the form of legal cases that come up to him. And he's pretty careful once he gets on the court to confine his utterances to his job.
Of course, this is in a period when you have established religions in the
Yes.
state, some of which don't die out until the 1830s. So for his entire tenure on the court, there are established state religions whose constitutionality is unquestioned and unchallenged.
Yes, and Barron v. Baltimore, of course, would uphold that.
That's right.
He says that the Bill of Rights does not apply to the states.
Next question. Yes, Professor Thomas.
Thank you. To follow up on your remarks about Marshall's jurisprudence on the question of slavery, did he leave us reflections, as Jefferson did, on the institution of slavery politically and morally and its future in the American Republic?
No, he doesn't. And this, I think, is where he most diverges from his the Federalists that he so admired, George Washington and Alexander Hamilton. And, you know, Washington frees all his slaves in his will. Hamilton helps found the New York Manumission Society. Marshall accepts the institution as it exists. There's just a poignant moment at the end of his life. His personal slave was a man named Robin Spurlock. He was a wedding present to Marshall from his father. His father gave him 3 horses and Robin. And at the end of his life, Marshall's writing his will, and he says that if Robin wants his freedom and moves to Liberia, I give him his freedom and $100. If he chooses freedom and moves out of state, I give him $50. If he chooses freedom and stays put, give him his freedom. Or he can pick whichever of my heirs he would want to continue to be enslaved by. Robin is in his 70s when this happens. Now, you're not going to go to Liberia. You know, he doesn't want to leave Richmond in all likelihood unless he had family somewhere, which evidently he didn't. He picked Marshall's daughter and, you know, lived out the rest of his life. So, you know, I contrast that with George Washington. I mean, slave owner though he was all his life, in his will, he says, all the slaves that I own shall be freed at the death of my wife, and he's very emphatic about this. And so,
financial provision.
And he's left enough money that those who are too young, you know, those who are kids, can be educated to some trade. Any who would choose to continue to remain as slaves can be supported. You know, he has left, unlike some of the other great founders who died bankrupt, he doesn't. So yeah, that's a sad thing. That's a disappointing thing.
More questions? Yes, Professor Strang.
So far you've dodged commenting on applying Marshall's life to the current Supreme Court. Let me try again. So you described Chief Justice Marshall as great or influential primarily by his substantive contributions to American constitutional law. So you mentioned the Contracts Clause a number of times. You mentioned his originalism of various sorts approach to the Constitution. Our current Chief Justice, whether one believes it or not, projects a persona of being politically neutral, of moving away from that kind of Marshallian picture that you're drawing. And I'm thinking of NFIB versus Sebelius, where somebody talked about a negotiated opinion and leads to a Commerce Clause result that is conservative and then a practical result that arguably is more liberal. Is one of the implications of your biography of Marshall that Chief Justice Roberts, if he wanted to be a great Chief Justice, would take a more substantive approach to American law?
Well, I think Roberts thinks of himself as Marshallian, and I think the way he's trying to do it, the aspect that he's trying to imitate or emulate is just what you pointed out, with these, finely sliced, compromised decisions. But he's trying, as Marshall did when he decided not to challenge the Judiciary Act of 1802. Let's not fight over the fact that we lost our summer term and that all these judgeships were gotten rid of. Let's just let that ride. And that was to take the Supreme Court out of the line of fire. And I think that's certainly something that Roberts sees himself as doing. And he would say, I believe, I mean, I've read that he's an admirer of Marshall. I've never spoken to him. I don't know about that. But I imagine if you grabbed him and gave him sodium pentothal, he'd say, yes, this is what I'm doing. This is what I'm trying to do. So is that like other aspects of Marshall's law ruling? Maybe not. But things are complicated.
Well, before I ask you to join me in thanking Dr. Brookhiser for his wonderful...
Mr. Brookhiser,
for
man,
his
that's the
wonderful,
cheapest doctorate.
Well, we should give you one. As soon as the Madison...
See, you don't have to go to law school. Just read Blackstone, and you don't have to get a PhD because Professor George will call you a doctor. So
in return for a great lecture. Only.
Okay, all right.
But let me make a couple of commercial advertisements here. Coming up, we have some lectures that I think you'll want to know about. Monday, March 4th, Michael Duran, former member of the faculty here, now of the Hudson Institute in Washington, D.C., will be giving a lecture entitled, Does America Have a Middle East Strategy? Now, that's a question that you want to know the answer to. So you'll have to come to hear Dr. Duran. Wednesday, April 10th, this is another one to put on your calendar, especially those who are interested in religious freedom. The very eminent University of Virginia religious historian Robert Louis Wilkin will be giving a lecture entitled The Christian Origins of Religious Freedom. This year's Charles E. Test Lectures, a very distinguished set of lectures that is given annually in the Madison program, will be given by Diana Schaub of the Political Science Department at Loyola University. Those will be 3 lectures that will be given Tuesday through Thursday, April 30th to May 2nd. Then in early May, May 8th, Professor Adrian Vermeule of the Harvard Law School will be here to give a lecture. It's our annual Herbert W. Vaughan lecture, Liberalism, Tradition, and Reasons of State. And then finally, mid-May, May 14th and 15th, we have our annual conference. And this year's conference will be entitled Religious Particularity and Moral Universality, Faith, Reason, and Natural Law. And the annual lecture will be given by our honoree. An award is given each year to an honoree for that conference. And the keynote address and honoree will be Rabbi David Novak of the University of Virginia, who I know is familiar, very distinguished scholar, familiar to many of you. So please do put those on your calendar. Come and join us. And now please join me in thanking Dr.